You know how sometimes you hear a legal term and it sounds like it's from another planet? Well, today, we're going to tackle two of the most powerful ideas in all of law. And we're not going to use some dusty old textbook. Nope, we're going to do it with a simple story about a bouncer at a nightclub.
So let's start right there with our bouncer's dilemma. I want you to forget the courtroom for a minute. Just picture this. You're standing at the velvet rope of a super exclusive club, and the whole show is being run by one person, the bouncer. And that bouncer has a very, very specific set of instructions.
Right there on the club door, there's a sign. It's not long, it's not complicated, but for everyone trying to get in, it is the absolute law of the land.
That's all it says. Entry from members only. Seems pretty straightforward, right? But what's so cool is that this one little sentence actually holds two powerful, kind of unspoken commands that tell the bouncer exactly what to do.
Okay, so first test. Someone walks up. They're not on the list. What's the call? Well, the bouncer's first job is to interpret that sign. They have to figure out what those words, members only, really truly mean.
But let's take it a step further. What if this person is, say, a good friend of the bouncer? Or they just seem like a really cool person who would fit right in? Can the bouncer just, add their name to the list? This gets to that second, deeper command, a rule of restraint that really defines the limits of the bouncer's power. And believe it or not, that bouncer's entire thought process is actually guided by two ancient legal principles with some seriously fancy Latin names. And these are the exact same principles that judges use in courtrooms every single day.
So here they are, our two big ideas. On one side, you've got Expressio Unius. That's a rule of interpretation. It tells you what the list means. And on the other side, you have Casus Omissus. That's a rule of restraint. It tells the bouncer what to do about stuff that's not on the list. So one interprets the words, and the other one stops you from changing them.
All right, let's break down the first one. And yeah, the full Latin is a mouthful. Expressio Unius Est Exclusio Alterius. But all it means is that when you specifically name one thing, you are automatically excluding everything else. So by saying members only, the sign is also screaming non-members are not allowed. It's just logic. The specific mention of one group excludes all the others. And that's how our bouncer knows to turn the non-member away.
And now for the second rule, the one that ties it all up, Casus Omissus. This is the one that tells our bouncer they can't just pencil in a new name on the list. And why is that? Because the law assumes that if someone was left off the list, it was done on purpose. The gap is intentional. It's not the bouncer's job to fix what isn't broken.
Okay, so the club door logic makes sense, right? Now let's take that exact same thinking and drop it into a real-world legal fight about a city's parking fees. This is where the theory gets real, and it gets real fast.
So here's the law. It gives us a very clear, specific list of who gets a break on parking fees. But then a problem arises. A pregnant woman parks her car and she argues that, hey, she should be exempt too. So what does a court do with that?
This is literally how a court would analyze this, using our two rules like a checklist. Step 1. Apply Expressio Unius. The law expressed two groups, seniors and PWDs. That means it excluded everyone else. So sorry, pregnant women are not on the list. Step 2. Apply Casus Omissus. The pregnant woman is what's called an omitted case, and the court has to assume the city left her out on purpose, so the court can't just add her to the law.
So the legal conclusion becomes really straightforward. The exemption does not apply to her. And look, the court's job here isn't to decide if the law is fair or nice. It's to apply the law exactly as the legislature wrote it.
Now, I know what you might be thinking. This all sounds incredibly rigid. Is it always this absolute? Is there ever a time a court can just ignore these rules? Well, the answer is yes, but the escape hatch is tiny, and it is reserved for only the most extreme situations. A court can only set these principles aside in two very specific cases. First, if following the rule to the letter leads to a result that is just completely absurd or nonsensical. Or two, if there is rock-solid, irrefutable proof that leaving something out was a genuine typo that totally wrecks the law's main goal. And let me tell you, the bar for proving either of those is sky high.
And this gets to a really important legal idea of what absurd actually means. Look, excluding pregnant women from free parking might seem unfair, maybe even uncharitable. But it is not legally absurd. The law still works, it's still logical, it just doesn't include everyone. And it's not the court's job to rewrite it to be more charitable.
So why did we just spend all this time on two obscure Latin phrases? Well, because they're not just some legal trivia you can ignore. They are absolutely fundamental to the logic of our entire legal system and to the balance of power in our government.
The best way to think about them is as a team. They are two sides of the exact same coin. Expressio Unius is the rule that interprets the list, figuring out who's in and who's out. And Casus Omissus is the enforcer. It's the rule that stops judges from messing with that list.
And when you put them together, what you get is the foundation of this huge legal concept called judicial restraint. These rules make sure that the power to write laws stays with the legislature, the people we actually elect to do that, and that judges stick to their job, which is to apply those laws, not rewrite them from the bench.
And all of this leaves us with one final, really important question to think about. If a list that's written into law isn't actually final, and if a judge can just add things to it based on what they think is fair, then who is really making the law? It's that crucial line between interpreting the law and creating it.